Not the first time that the first petitioner is making such allegations about judges. He did so in 2023 about your sister, Lady Justice Esther Maina. In the letter addressed to the Deputy Registrar, and I refer you to paragraph 10, he insinuated, in paragraph 10, he says the lightning speed with which the Kirogoya file was grabbed and directions issued seems like a well-orchestrated plan to trample on the rights of the petitioner. They made allegations against the Deputy Chief Justice. In the same letter, they have asked an investigation be done in which they insinuate the conduct of the Deputy Chief Justice, the Chief Justice, so that, my lords, they have made allegations about 6 judges.
Your Lordship, I'm constrained to interject. My learned friend and my very good friend, Mr. Mushemi, is alluding to going to talk about some grounds which he says were before the Senate, but which were dismissed. So,
no. That is not correct. Ground number 4, to correct my learned friend, was supported by 51 senators out of 67. It was one of the charges that was upheld by the Senate.
My Lord, those are the matters that are in the petition, and that is where we are before you.
Let us restrict ourselves to the application.
Most obliged.
Yes, my lords, the nexus of this application, the nexus of my response, is that the first petitioner has impugned the conduct of 6 judges. This has never happened before in this country, that one person is unhappy about 6 judges. At the same time, my lords, you have been treated this afternoon to issues of bias. The first petitioner had his day before the National Assembly. In that house, 282 members of Parliament voted to impeach him. Out of those 282 members, a majority of them were from his own party, United Democratic Alliance, where he is the deputy party leader. They were not biased against him. The matter went to the Senate. 53 senators, a majority of them from his own party, voted to impeach him. He did not raise the issue of bias. My lords, you have been treated to the issue of weddings. Weddings by the petitioners. I ask this court to take judicial notice that in the National Assembly, and my learned friend Kibe Mungai spoke about our tradition, we come from the same community, the first petitioner last year attended the wedding of a member of parliament, Eric Wamumbi, member of parliament for Madeira, where the first petitioner comes from. That member of parliament subsequently impeached him. If the basis of closeness is the basis of impeachment, how would somebody who have attended his wedding impeach you? But he did not impeach him because of attending his wedding. He impeached him because of serious violations of the Constitution. So that if the issue here is a wedding being attended, the first petitioner himself has attended a wedding, and not just as an ordinary guest. He was the father of that member of parliament in that wedding. But he was still impeached. So that, my lords, I want you to take comfort. Those are matters before the Hansard of the National Assembly, which is evidence before this court. Your lordships should take comfort. The first petitioner in the National Assembly, he impugned institutions, In the Senate, he impugned the Ethics and Anti-Corruption Commission, the National Intelligence Service. He has now impugned the conduct of IEBC. He has now impugned the conduct of the National Assembly. He has impugned the conduct of the Senate. He has impugned the conduct of the executive. So which institution does he have faith in this country? It appears that there is none. My lords, eminent judges, it is a matter of judicial notice that your esteemed colleagues, although the petitioners argue that you are unfit to hear this matter, have elected one of you, presiding judge, to be a principal judge. Your own peers, through a peer review. All judges in the country have elected one of you to be principal judge. Your peers equally have elected one of you to the Judicial Service Commission.
My lords, our application is limited to your lordships and her ladyship, not the other judges. And there are many outstanding judges in this country with courage, with everything. The petitioner has not cast aspersions on judges generally. We've stated our grounds for the application for recusal of this particular bench.
Your Lordship, the character of judges in this session has been impugned by several counsel appearing for their clients, and it is important that we rebut the issue of their character.
Proceed, please.
Thank you. Your Lordships, my client, the 9th respondent, has also filed a public participation report before this court. 200,000 Kenyans exercise their right of public participation in the National Assembly.
What has this got to do with the recusal? That's the only thing we argued, my lords.
If my learned senior would be patient, I'll show him the nexus.
Yes, if you are relevant, admissible submissions in reply to the issue we argued.
Exactly. You want to let him stick to the application, which is recusal.
My lords, I thank my colleagues. The basis of the public participation, and my lords, when you retire, you look at this. 200,000 Kenyans conducted or went through public participation. 65% of them said that the first petitioner should be impeached. That report is in my client's affidavit. And the reason I am saying this, my lord, is that the nexus of this is that the first petitioner has no confidence in all institutions. He has no confidence in 6 judges. He has no confidence in all Kenyans who went through public participation.
Objection.
He has no confidence in anything.
Objection, Your Ladyship, Your Lordship. What is being advanced by Melania Senior will be discussed at the merits, including the character and the conduct of public participation. Is it fair for him to go on ad nauseam despite various objections? We strongly object to that line.
I think, my lord, it is relevant if a litigant has cast aspersions against the court. Some of them he even wanted to withdraw. It is only fair, and it is actually relevant, that the court be shown this is a person who picks the candles not just against the court, but against every known agency and institution of the state.
My lord, I was just trying to keep quiet because of this intervention.
Finish. Well,
My lords, I was finishing.
Take time and finish, and please sit down. You'll respond. Finish.
And I have been very kind to my learned colleagues. I did not even apply that their pleadings be struck out, even when they were fatally defective. I have said let them remain on record. We are not impugning them. So I am being very kind to my friends. Finally, your lordships, if you recuse yourselves, you will do a great injustice to the oath of office that you took, the administration of justice, to allow the petitioners to bully you, to forum shop, They have tried to bully the National Assembly, the Senate. Now they are trying to bully the judiciary. Will be a great injustice to this country. That is all, Your Lordships.
Thank you.
The respondents rest there.
Oh, Professor.
Sorry.
Presiding judge and distinguished members of the bench, Mahat Somane for the IEBC. I think everyone is in the arena, the independent body. No one wants it to talk. I think we have something to say about these proceedings. The leadership, the IEBC's position is the Independent Electoral and Boundaries Commission, the 16th respondent in this second cohort. The IEBC's position is that the court should stick to first principles when it is determining the issue of recusal. We have been listening keenly to the submissions by the various parties, and our position is that the court has a three-tier constitutional doctrines that it has to satisfy itself. The first one, when the court is determining the application for recusal, is whether there is reasonable apprehension of bias. The question the court should ask itself is, do the circumstances give rise to a reasonable apprehension in the mind of, number one, a reasonable person, number two, a fair-minded person, and number three, an informed member of the public. So the test is all those three criterion has to be met. The second constitutional criterion that has to be met is the presumption of impartiality of judges pursuant to the oath of office they took must be rebutted, and that with probative evidence, not on aspersions, not on allegations, with probative cogent evidence. The third one, which is also a third constitutional doctrine, is judges generally in our constitutional dispensation have a constitutional duty to sit. We give them security of tenure. We pay them from the consolidated funds. They have a duty to sit and to hear all matters. And that duty can only be rebutted when there are valid grounds relating to it. We refer the court to the authority which has been placed before it, Sholei and another versus Judicial Service Commission, petition number 34 of 2014. We refer the court to paragraph 5 of the said decision as relates to the duty to sit in every matter and not to choose on any allegation that is made on it. We refer the court to paragraph 16 of the said judgment, the very analysis done by Justice Mohammed Ibrahim and the dicta of Lord Denning. We refer the court to paragraph 27 as relates to recusal and reassignment. And if the court applied first principles, the position of the Independent Electoral Commission is the threshold has not been met. The matter should be expeditiously disposed by the court. Thank you.
That is the respondent's